Welcome back to Canadian Justice, where we're discussing the fight over the Emergencies Act and the government's claim of cabinet secrecy over documents that explain why they invoked the law. Now, Sujit, the government is claiming cabinet confidentiality over these documents that we think would provide some insight into their reasoning for invoking this law. How do Canada's laws on cabinet confidences compare to other Westminster systems? Are we more secretive? Are we less secretive?
So our laws are perhaps the most secretive in the world among Westminster democracies. So in the other Westminster democracies, and here I'm just referring to Australia, New Zealand, the United Kingdom, not the other parliamentary democracies, but those are the main ones. And also at the provincial level, and this is quite important, the cabinet privilege is a common law privilege, and the courts engage in a rough balancing test to determine whether cabinet privilege in a particular case should give way to other important interests. But at the federal level, Section 39 of the Canada Evidence Act vests in the clerk of the Privy Council, who's the head of the Federal Civil Service, the power to issue something called a certificate and to declare that certain matters, certain cabinet materials should be confidential. And what the provision actually says is that that certificate can't be questioned in the court of law, more or less. And so there's no other jurisdiction that has a law like that we're aware of.
So what you're saying is that the federal government has a law, a statute that actually allows for even more secrecy over cabinet documents than they would have under common law.
That's true, and we're also saying that there's a reasonable apprehension of bias here because what's at stake are the decisions of the very body that essentially has the power to declare these materials confidential.
Wow. So, I mean, it's certainly concerning from a transparency point of view. And when it comes to legislation that is so extraordinary, the Emergencies Act, that's supposed to be invoked for wars or terrorist attacks, for the government then to claim there's no ability to get any insight into why they invoked it, it's a huge transparency problem.
Sorry.
Sorry, go ahead, Sujit.
Well, I was just going to say, I mean, I think it's important to put this in context, right? So if the government had provided a better set of materials to Parliament that provided a more comprehensive and transparent explanation of why it had concluded that the existing legal tools were ineffective in dealing with the blockades and the protests, then we might not be here. But that's not what they did.
They had that one sentence, right, in their document that was an unsigned, unsworn document tabled in Parliament.
And at the same time, right, they are invoking the fact that, or they assert that the discussions within cabinet were robust. And so we say they can't have it both ways, right? They can't both assert that discussions were robust, which is a tool designed to induce deference and trust on the part of Parliament and the public, but then on the other hand, refuse to let us examine the documents that would let us assess whether, in fact, those discussions were robust or not.
Very well put. Now, Janani, there is going to be an inquiry about the federal government's use of the Emergencies Act. It's an inquiry that the government's not doing out of the kindness of their heart. It's required by the legislation. But what can you tell me about it? How long might it take? What tools might it have?
So Justice Rouleau of the Ontario Court of Appeal has been appointed the commissioner of that inquiry. They're required to produce a report in February of 2023. So that's the timeline that they are working with. And just in terms of like a high level overview of what the purpose of the inquiry is, they're going to be looking at, why are we here? Like, why did the federal government invoke the Emergencies Act? What is the justification for invoking the Emergencies Act? Did they have the requisite reasonable grounds to invoke the Emergencies Act? And lessons learned. What can we take away from this going forward in terms of future emergencies and future opportunities to invoke the Act?
And who are the groups that are going to be participating in this inquiry? Is there an opportunity for public participation, including participation by the Canadian Constitution Foundation?
So the inquiry has invited people and organizations to submit an application for standing at the inquiry. The Canadian Constitution Foundation intends to apply for standing and participate in the inquiry. It'll be up to the commissioner to decide who gets standing and who has the ability to participate in the inquiry.
Well, we'll obviously be watching very closely and hopefully be granted standing to participate. We're going to talk a little bit more about what that means when we come back.